Alright guys, we're live in 3, 2, 1.
And welcome to Legal Tonight. On tonight's segments, we'll be talking about trial with our hosts.
Caitlin Archer-Wiitala.
And Emma Tabasna.
Alright, I'm Ryan Hamza, and we will be talking about two types of trials for tonight, civil and criminal. Civil is decided by preponderance of the evidence, 51% of the jury, and criminal is decided beyond a reasonable doubt, which is where a jury must unanimously decide on the verdict.
When preparing for trial, a lawyer must first develop a theory of the case, which is their position on, approach to, all of the evidence that will be presented at trial. It is important that the theory of the case is developed before the trial begins because that approach to each phase of the trial is dependent on the theory. Their position must remain consistent during each phase of the trial. At the conclusion of the trial, their position must be the more plausible explanation of what really happened, according to the jury.
The next step in preparing for trial is the pretrial conference. It's a meeting held before trial between the attorney and the judge. It's an informal meeting, but its purpose is to identify any issues in dispute and the evidence that will be presented. The next step is a pretrial order. This is an order that acts as a guide for trial. It identifies the issues, the witnesses, exhibits, and then the order of proof. Continuing on, you would select the jury. The procedure of jury selection can vary from court to court. In general, prospective jurors come in, take their place in the jury box, and then at that time, either the judge or lawyers, depending on the court's practice, will conduct a voir dire of the jury. As a lawyer, witness preparation is very important. Witness preparation is not the time for discovery. This is the time to obtain a favorable outcome for your case. A witness must be prepared for testifying in court to those facts that will support your side's theory of the case. Preparation can involve reviewing those facts that each witness will provide and preparing the witnesses to testify those facts in a convincing fashion. If a witness is not party to the lawsuit, the witness will need to be served a subpoena to appear at trial. Part of preparation for trial is to ensure that all of these subpoenas are served on non-party witnesses before the day of the trial.
After selection of the jury, the lawyer for each side will present their opening arguments. Opening arguments are the initial statements made by each side to present their case and what they plan to prove. After each side makes their opening arguments, each side gets the chance to present their cases in chief and examine their own and each other's witnesses. The plaintiff first presents their facts and evidence in their case before calling up their witnesses for direct examination. After the plaintiff asks their questions, the defendant may then cross-examine the plaintiff's witness, ask them any questions they may have. The defendant then has their chance to present their case in chief and then call their witnesses up for direct examination. The plaintiff then has the opportunity to cross-examine any of the defendant's witnesses. Following the cases in chief and examinations, the plaintiff has the opportunity to respond with a rebuttal. The plaintiff may offer rebuttal evidence only if it contradicts specific evidence offered by the defendant. Rehashing of the cases in chief is not allowed. The defendant also has the opportunity to present evidence that explains or denies the rebuttal evidence in their surrebuttal, with the same rules applying. After both sides have presented their evidence in any rebuttal, surrebuttal evidence, each side will make their closing arguments to summarize the important evidence presented at trial and explain why the judge or jury should rule in a particular way. The lawyer should keep several blank sheets of paper throughout the trial so that they can note different ideas that arise throughout the trial and testimonies that will help them conclude their closing argument.
In jury deliberation, it's a process where the jury goes into a room and privately discusses the findings of the court. The jury debates the case until they reach a unanimous decision and decide on a verdict. All federal cases require a unanimous verdict. If jurors do not reach a consensus, then they are considered a hung jury, and the case may be considered a mistrial and will have to be retried again at a later date with a different jury. In the end, there's the verdict. There are types of verdicts. For a criminal case, it's guilty or not guilty. And for a civil case, you can either accept or appeal. To accept, you abide by the conditions and terms set forth by the court in the verdict. And to appeal, parties must request a formal change to an official decision. There are also economic and non-economic damages that you can pay or appeal in the end of the case. Thank you for joining us tonight.